Clear mention.
May I give a lordship's kind leave, my lord, to file a mandamus appeal without the certified copy. My lord, I have preferred, my lord, sought for made an application for the certified copy. The order was passed on 17th, my lord. So, certified. Yes. November. Kindly, my lord, grants me leave. Urgency? Urgency is that, my lord, the process for recruitment, my lord, and teachers' eligibility test is going on. The petitioners are, my lord, having the eligibility criteria to participate in the teachers' eligibility test. And, my lord, they are pursuing a particular course, but they have leave granted. Yes.
May I permit to mention, Lordship, matter I had your application, Lordship.
Application, are you mentioning upon notice?
Lordship, I am serving notice, Lordship. Lordship, 2017 order is passed by the Honorable Justice Nishida Matra and
It's the first time it is appearing.
no, sir.
It appeared earlier.
Lordship, earlier that's been 2017, Lordship.
So then what happened, sir? Any direction for affidavit?
Lordship, all are is process
So
complete.
suddenly why you are mentioning
Lordship,
after 9 years?
Lordship, I am a private respondent, Lordship. I am a, but the petitioner is.
You should have said that first.
Lordship, 2017 order is passed by his Lordship and Honorable
Sir,
Justice.
how can we help you? You have not filed the appeal.
No, I am filed the application.
Maybe
Recalling order. I am application for recalling, Lordship.
recalling of order of 2017.
2017 and recalling application for file 2017, Lordship.
So when was it served? Recalling application?
Recalling application heard by his Lordship and Honorable Nishida Matra and direction to the petitioner to file a video opposition reply. All our process is complete, Lordship. Petition long time the petitioner has not mentioned this matter, Lordship.
Now slipটা নাও দেখো requisition করো ফাইলটা
Yes.
My lord, may I lordship, I need to mention, maybe to be mentioned, because this petition against whom the appeal was filed, she died. But this is my lord.
appellant has
Appellant
expired.
Stay. The writ petitioner died.
You are for the state.
Writ petition. I mentioned with notice to the state. My
But
lord,
you have come, did you file an application for this?
He is already dead. This is my lord, I want my lord to this may be disposed of.
How, Mr. You are not the appellant?
No, that's right. That's right.
If
But
they don't take steps, it will stand
the
abated.
petition is dead. There is a case of extra benefit of his educational qualification. We are not asking for anything. You can dispose of this matter, quashing this all order. Matter because she is dead. There is no legal heirs. Only the person, his brother, he was assigned.
Appeals stand abated as
His brother died. She died. The petition is died. There is no
appeal
legal heirs
abated.
to contest this.
Why you are insisting in listing
Because
this
of
matter?
that-
It has already abated.
But yes, but that's why. But unless the benefit, retail benefit, his brother, his elder brother, whom she has assigned, he will not get unless this appeal is withdrawn or disposed of or anything. This is already abated because they are not claiming any further benefit of that, the order passed by this court. So this order, my
You are
lordship,
appearing for whom?
I am appealing for the person,
Who has expired?
yes, ma'am.
Then how can you appear?
His brother is
Brother has to come within the fold, then
yes,
appropriate
file
application
an
is.
application.
File an application.
Lordship.
Yes.
May I have your lordship's kind leave to mention this matter? Your lordship was pleased to appoint a commissioner to ascertain the mean profit, my lord. The commissioner has ascertained it, my lord, but the report cannot be.
Our matter,
My lord, it has been specially assigned to your lordship's, my lord, this appeal.
is original side or appellate
My
side?
lord, appellate side, my lord.
So then for what are you mentioning?
My lord, I'm mentioning for inclusion in the list so that the learned commissioner can file the report, my lord, because until and unless the matter is appearing, he cannot file the report. He's ascertained the mean profit, my lord, but further steps cannot be taken. Then we'll have to take exception, my lord, to the report, because he is not giving us a copy of the report until the time your lordship takes that report, my lord. For ascertainment of mean profit, your lordship had granted us liberty
You
to mention.
mentioned this earlier, no?
Yes, your lordship was pleased to allow also, my lord, but then it has not appeared, my lord. Your lordship granted us liberty.
Commissioner was appointed to ascertain the mean
Mean profit,
profits.
my lord.
Now, commission, there must have been a direction for filing it within a
No,
certain
no, my
time.
lord, that is not there. That is the difficulty, my lord.
Show us the order.
The order. Lordship had granted us liberty to mention, my lord.
এটা একদিন to be mentioned এ দিয়ে দিই।
Grateful.
Or may I have your lordship's kind leave to mention an application my lord, for inclusion in your lordship's list? We have served, but what I find from the affidavit of service was done long back, my lord. May it appear, my lord, I shall again serve the other side, my lord. The affidavit of service is annexed to the mentioning application slip, but the affidavit of
Which
service,
year matter?
but 2023,
You are the appellant.
my lord.
Then what happened?
My lord, service was made, but service with regard
The
to
application was not
no,
heard.
service was with regard to that I am being mentioning today has not been effected, my lord. That is the candidate, my lord, submission from me, my lord. Service is there, but it is a long back affidavit of
To
service.
give a notice to the advocate who is appearing.
Ma'am.
Give a notice and
Ma'am.
come back.
My lord, may I have your
Yes, sir.
Secretary, I mentioned before your lordship.
Leave from justice. Wait. Yes.
may I have your lordship's kind leave to mention one matter, my lord. On 19th,
Application.
no, my lord. On 19th November, your lordships had heard me on a contempt matter. 6 contempt matters were there. 2 weeks had been given, but the next date has been showing as 3rd December because the 2 weeks comes in 3rd December. But kindly fix the matter on 5th instead of 3rd, my lord, kindly for personal
That
difficulty.
cannot be done. Let it appear you mention at that time.
For personal difficulty, I may not be able to
Ask
appear, my
somebody
lord.
else to say, remind us. Yes. How can we prepone or postpone the date without the other side being here?
Well, I will inform the other side,
The
my lord.
information won't help. Now we have kept the bunch of writ petitions. Ask your
No
senior.
in the order, no date has been given, my
So,
lord.
madam, please mention this fact when it is taken up. You ask any of your friend to mention. Yes.
Grateful, my lord.
If to move this appeal without the certified
When was
copy,
the
the
order?
order was passed on last Thursday, my lord, 28th, and I want to move the
You are
application.
so urgent. You are so urgent that you cannot apply for
I-
certified copy.
I have applied for certified.
When did you apply?
I applied today, my lord. The order was uploaded on Friday. I applied the certified copy today
So
itself.
wait for 2 days.
My lord, there is urgency, my lord. This pertains to admission of a student in the MBBS course, my lord. The students, the learned single judge has found out the student has filed forged affidavit. The chief
Then there
judicial
is no
magistrate,
urgency, sir.
my lord. Now, even after that, the learned single judge has allowed his admission, my lord, and has directed
Who are
that
you then?
I am the college, my lord.
You are not the appellant. Are you? You want
I
to
am the
take-
appellant, my lord. He is the writ petitioner. I am challenging the order passed in the writ petition where his admission has been allowed, my lord.
Yes.
Now, the urgency is that prima facie, he has found that he has filed forged document before this honorable court, my lord.
Comply with the court's order.
And
Allow him admission. A writ petition
My lord,
will be pending.
that is the difficulty, my lord. My lord, the learned single judge, my lord, the learned single judge has directed. My lord, the learned single judge has directed to initiate police.
Urgency. We
My
don't
lord, kindly,
find
just
urgency.
kindly hear me one
This
minute.
has become a practice, it seems, that we
No,
will
my
get the order in the
My-
server, we will directly go.
My lord, I have applied for certified
So
copy.
maybe you have applied today, na?
My lord, the order was uploaded on Friday, my lord.
Very good. You applied. When did you apply?
Today itself, my lord.
Where is your application? You filed the application and came running to the court. You
My
cannot.
lord, there
wait
is
for
urgency,
also-
my lord, because he is going to start with the classes, my lord, and the learned single judge has directed to initiate the investigation, my lord, and has also stated, my lord, the order is there, the impugning order is there, my lord, and also directed that upon investigation, if it's find out that he is guilty, then his admission along with everything will be, my lord, cancelled.
Then what is
Then-
the problem?
The problem is that, my lord, kindly understand that there can be a mop-up round, my lord, next week. There will be a mop-up round. My lord, for him, an eligible student who has that seat, my lord, will not be able to take that seat, my lord.
This is
Now, my lord,
private quota.
private quota. Now, my lord, kindly understand. This is not private quota. This is state quota. State quota, my lord. State quota. I apologize. My lord. This is a state quota. Now, kindly understand, my lord.
We do not appreciate this conduct of yours.
My lord, I apologize, my lord, but the order was passed on Thursday. It was uploaded on Friday. I have applied today and came to itself, my lord.
কবে দিতে অ্যাডমিশন কবের মধ্যে দিতে বলেছে বলে লাস্ট ডেট অফ অ্যাডমিশন প্রভিশনাল সাবজেক্ট টাইম পিরিয়ডও দেয় ফ্রেশ বন উইদিন শিডিউল টাইম টু ও দেখো আমি কি আর হাতে সব রাইটার দিয়ে রেখেছি
Subject to the admission of the petitioner subject to the final outcome of the pending criminal case. Same situation, there is no change of circumstances. There is no change of circumstances, so what new order would be passed by this court?
My lord, the fact is a
Prima
person,
facie,
my lord,
your claim is that the student is seeking admission in the course on the basis of a document which according to you forged.
my lord, not only according to me,
According
Chief
to you,
Judicial Magistrate by a letter has also.
Criminal proceedings is also going on.
Yes, my lord.
So this court is not here to say whether this document is forged or not.
And I'm not asking for that also.
So-
Kindly visualize the situation, my lord. He has taken, I'm sorry, my lord.
So there is no change of circumstances.
Kindly visualize the situation.
There is no change of
lord.
circumstances which was
From Thursday to
Lord,
today, there is
single
no
bench.
change in circumstances.
Same circumstances will prevail before this bench also.
Kindly visualize this, which the learned single judge, my lord, we could not satisfy learned single judge on this point. The kindly visualize the situation. He has taken admission, my lord. Then upon investigation, it has been found that he has been guilty, my lord. Kindly understand.
Upon investigation,
My lord,
investigating
kindly
authority will
come to
not
the
say.
page 3 of the impugn order, my lord. Page 3.
It is the court which will say. Investigating authority will not say.
The
He
court
say,
only,
prima
my lord.
facie,
The
case
court,
has been made out and hence I
brother,
filed charge sheet.
my lord, the criminal court has found out that he is guilty.
wait till Thursday. If you don't get on Thursday certified copy, mention. Yes.
My lord, I'm mentioning for inclusion in the list, my lord, application matters.
Huh?
Application matters, my lord.
My lord, another fact, my lord, I'm sorry, my lord.
You have
The matter is
wait.
my. Look, all pichon থেকে।
New application. Have you served copy? Served copy and mention. Yes.
My lord, I crave leave to mention one group 2 application of 2025.
Which year?
2025.
Why it did appear?
No.
Did it appear?
No,
When did you give the returnable date?
yes. Pardon your lordship.
When did you give the returnable date in the filing?
No, I don't.
Notice the now.
19th.
On 19th. On 19th.
Do you know? You are sure?
Yes, it is. It is there in the notice.
Yes.
Lord, I am mentioning for a typographical correction on the order dated on 19th November 2025, item number 21.
What typographical error?
My lord, date mistake.
Huh? Date to be mentioned in the.
My lord, may I just one thing? The writ petition is returnable on Thursday, my lord. I won't get certified copy before that, my lord. If my lord sees the order, the writ petition has not been disposed of. It is returnable on this Thursday, my lord. That is the reason before the writ petition is taken up, I'm trying to impress upon your lordship that the order passed by the honorable single judge.
Thursday গিয়ে বলবে apply করেছি pending।
He has taken admission. He is going to start with the class.
When?
My lord, probably by today, my lord. My lord, today might be he is going to the college today itself, my lord. And our fact is, my lord, when he has taken admission, my lord.
To allow him to study.
My lord, we will, my lord. Just for that, my lord, kindly grant us an opportunity on by Wednesday so that we can impress upon your lordship that there is some.
Leave granted.
Get it, and the stay application be returnable on Wednesday, my lord. Kindly.
Just as I am mentioning the matter, the interim order is going to be expired on this one, 30th.
Yes, we have copy রেখেছি জানো। It will at least it will come out on Wednesday at 1 PM. We have kept it. আজ একটা সময় না।
Shall I hand over this to you?
Not required. It has been. Anyway, you give it. Please keep a watch on the list. We have kept it.
Another thing is another request, my lord, your lordship is taking up Group E. If any date is fixed for Group 8 matters, my lord, Group 8 matters
We'll consider. Yes.
as well. This is our contempt application. Lastly, when this matter was taken up by your lordships, your lordship was inquired from my learned senior friend.
Yes, Mr. Vasu.
Lordship, I had called my clients in my chamber, but what I could gather from them is this: the Supreme Court advocate has said that I cannot file it even without the certified copy. I cannot file it even without the certified copy. Lordship, I'm not very aware of the Supreme Court rules and the filings of this, but this is my instruction, and I was not possibly correct the other day when I said that it has already been filed. So this is my submission before this court, Lordship.
So as on date, there is no appeal.
Lordship,
There is no special leave to appeal, and there is no appeal also.
13th of February 2024 is your order passed by your lordship's court at page 34 of the contempt application.
Now, SLP has been filed or not?
No, my lord, as I have gathered,
SLP has not yet been filed.
কি বলছি স্যার?
SLP, you don't know whether it has been filed. It has not been filed.
it has not been filed, Lordship. I know that for sure. It's not been filed because the certified copy apparently was not over there.
Page 34, 13th of February 2024, the operating part starts from page 42. Kindly takes page 42 of your lordships.
The present contempt application has been preferred, alleging
Mr. Rajorshi Basu is appearing on behalf of state in this matter.
Well, I am appearing on behalf of the writ petitioner respondent in this matter.
I am paying for a short pass.
You are a respondent, sorry. Let the appellant who has filed the appeal, let him say, my lord, what is his submission.
Yes, my lord.
Oh, he is there to
Service
assist Mr.
secretary
Basu.
has returned, my lord.
My lord, one preliminary point I am taking, the learned advocate Mr. A. Ali, who is appearing on behalf of the private respondent here for leave to appeal, was an advocate for the state government, or advocate for the school authority in the trial court. Now, school is disobeying the order of the direction of the trial court, and he is holding the brief for a third party, seeking leave of the court on behalf of him, in spite of a lawyer for the school, but seeking leave for staying the operation of the said order.
He appeared for the school.
For the school.
In earlier.
In this writ petition, against which the appeal is preferred.
His name has been recorded.
His name is recorded.
I have given no objection on that day, my lord.
Where is the
There
order?
is some professional.
No, I have
Can
given
you
no
Hey, Gaji, for school, this is the order. A copy can be.
follow some professional ethics?
Yes, my lord, I have given on that,
Can you, if
on that day, I have given no objection.
you represented respondent number 1.
School.
Subsequently, can you prefer appeal on behalf of respondent number 2,
Yes, my
giving
lord.
no objection to respondent number 1?
Yes, my lord, just I have.
Is it proper? Your name, Mr. A. Gaji. Your name appear?
I have appeared on behalf of the school.
আমি জানি তো বলেছিলাম
Sir, no objection, I have filed, my lord.
Or no objection.
Sir, why do you act in such a manner? Why do you act in such a manner?
দাঁড়িয়ে ছিল না
হ্যাঁ।
এটা একদম
বহুত দাঁড়িয়েছে অন্য ম্যাটারও দাঁড়িয়েছে
Actually, my lord, I have the introduction with read petitioner, my lord.
When did you file the no objection?
No objection on that day.
Which day?
Which, before filing of that is appeal, my lord.
Before filing the appeal.
Before
So after the order was passed, you gave no objection.
I have told over the telephone that I have given no objection.
Telephone will not do. You have to surrender your.
Thereafter, I have given no objection on the vocal of no.
Now, who is appearing for the school now? Anybody is appearing? Anybody is appearing?
But the person who preferred appeal before your lordship, alleging that he had a writ petition pending from 2015, challenging the panel 2015. In that matter, he also appeared for the school authority. Who is preferring appeal, his personal writ petition matter concerning the same subject, he appeared for the school.
My lord, I have given no.
Actually, if you closely look into the provision of Advocates Act, most probably you will not find it. But in court, we follow some professional.
Yes, my lord. Actually, what happened?
That
My lord,
ethics does not permit.
He's my student life from the student. He's my friend
It
actually.
is not expected that one advocate who
He has said that he is
represented in the same proceedings, representing the respondent, another respondent, he will prefer appeal. Challenging the same, appeal is nothing but a continuation of the original proceedings. So it may be the same proceedings.
ফারুক যে অ্যাপিল করেছে তার রিট পিটিশনে ও অ্যাপিয়ার করেছে স্কুলের হয়ে
So you consider whether your representation will be accepted or not.
ফারুক অ্যাপিল করেছে তার রিট পিটিশনে ও অ্যাপিয়ার করেছে স্কুলে
It is almost same proceedings. If we accept this appeal, it would be same proceedings.
I am ready for it. I am ready for it.
We don't.
And the appellant is Farooq. Farouk's writ petition, he appeared for the school.
No objection. No objection দিতে হবে না
ও ফাইল করছে ওই দেখো
হ্যাঁ ঠিক আছে না না আমি বলছি ও যদি
Leave to appeal has been filed on behalf of Farooq. Farouk's writ petition, my lord, he has appeared for the school. And he is alleging that Farouk's writ is pending, so do not proceed with the matter. Farouk's writ petition, my lord, he appeared for the school, even. In both the matters, but he appeared for the school.
It was same proceedings. It's a continuation of the original proceeding. Same proceeding. In same proceeding, you representing respondent number 1. In same proceeding, you are preferring appeal on behalf of respondent number
No,
2.
my lord, I am only I have appeared on behalf of these schools.
Right. Have appeared on behalf of the school. Etiquette applies, and it is, I cannot shift the stand in the midst of the proceeding. There is a procedure to do so. After I appeared, I send a no objection, file a writ again on the behalf of the party who is a party to the proceeding. This is not acceptable.
Is my great for
We could have initiated
I prefer
appropriate
leave for
proceeding
withdraw
against it.
withdraw the
So you never informed us. This is the 3rd time we are taking up the matter. And Mr. Bhattacharya none appeared on your behalf also, thrice.
My learned friend was not served with a notice even when the matter was listed. Oh, no notice was given of mentioning, no notice was given of listing.
When the order passed by Lordship on 7th, there was a direction upon him to serve a copy of the order. Even then, no copy has been served upon us.
Liberty to file on the same cause of action.
But no liberty is required, my lord, in this matter. This is absolutely expressly not maintainable.
Technical, it is mere
Cause of
technical.
action will be taken up by others.
Okay, on the same cause of action with liberty, because it is a matter of technical. It is not.
This is a sheer misconduct of a lawyer, my lord,
Otherwise, he will not be-
acting in this fashion.
It is.
And that liberty will, my lord, tantamount to non-compliance of the order of the trial court. As your lordship is absolutely convinced that this is a fit case where liberty should be granted.
No, who has come? Farooq.
Farooq is a person, not a party in the writ petition.
Okay. So
Farooq filed an independent writ petition challenging a panel of 2015. And that writ petition was dismissed for default.
Mr.
He got it
Bhattacharya,
restored after the order was passed by the learned trial judge.
we cannot snatch away the right of the Farooq to come. But
He is not a party here.
he is come.
Only leave has been filed, leave to
That
file.
is because you did not implead him. You ought to
He
have
was not
impleed-
supposed to be implemented because
Why?
my approval was granted.
Maybe.
After approval was granted, I was
When
not
you
allowed
were
to join
aware.
the school. I was not given the post of magistrate headmaster. I am a teacher.
For 3 years, you did not do anything. Suddenly, you wake up. There is a 498A proceeding pending against you.
For
You
that,
have
my
not
lord,
told us all these things.
for
This
that,
was not told to us.
that
You
was
are
recorded
also
by
not
the
so
court.
clean.
That was recorded by
So
the
you
court.
better you are also not so clean. If you allow us to go into the matter, we will go into the matter. But since you have taken this point, we are asking him to withdraw with liberty. His client cannot miss the opportunity to come before the court.
As your lordship. As your lordship.
The person cannot be deprived of. Mr. Gazi Lanet advocate.
Rajkot, yes, I am now working.
as
I-
assistant headmaster?
Yes.
Oh, you have been given the post.
Yes, yes.
And to that effect, your lordships pass a specific direction on the last occasion that you file a report. I have filed a report from the district inspector that he has joined and he has been allowed to function.
Next month কত হয়ে যাবে?
ছেড়ে দে, ঠিক আছে।
That report you have filed
Yes, my lord.
today.
No, my lord, on the last occasion, your lordship has taken it on record.
দেখবো।
Report dated, my lord, 11th of November 2025 from the district inspector of schools, not 24 Parganas. Now, my lord, the third page of the report, there is a communication from the school authority to the DI that Parvez is functioning as AHM.
না, আমার স্যালারি পেয়ে গেল।
স্কুল লিখেছে তো স্যালারি দিয়ে দেওয়ার জন্য।
You have got the salary as assistant headmaster?
No,
Not
that
yet.
is that is under process. Well, that indication is there. That is under process, my lord.
ও চ্যানেল করেছে প্যানেলটা।
জয়েন তো দিয়েছে এখন, অ্যাপ্রুভালের পরে জয়েন করতে দিয়েছে।
আমার জয়েন করতে দিচ্ছিল।
When did you join, Mr. Bhattacharya?
কবে জয়েন করেছে?
রিপোর্ট অর্ডার হওয়ার সাথে সাথে
কোর্টের অর্ডার সঙ্গে মানে জাস্ট ইমিডিয়েটলি আফটার দ্য অর্ডার অফ দ্য লার্নেড ট্রায়াল জাজ ওয়াজ পাসড। ট্রায়াল জাজ অর্ডারটা কবে ডেট?
No, a letter says that school's letter says that you were appointed on 23rd February 2015.
Yes.
But I was not allowed to join, my lord, by the school. In spite of approval given by the DI.
না, আমাকে বল।
জয়েন করে অ্যাপয়েন্টমেন্ট দিয়েছে কিন্তু জয়েন করেনি।
So the Acha.
Now, my lord, the next few lines. On and from 30th July.
Prior to the issuance of the DI order, you joined. That is what the DI say. Your school says that joined as assistant headmaster on 23rd February.
I was not allowed to join. That is wrong statement made.
No.
Then when did you join, Mr. Bhattacharya?
After the order of the learned trial judge, July 24.
This is a fact.
Yes.
Mr. Basu, this is a fact.
My lord.
This is a fact.
My lord. My lord, he has joined, but he has been not allowed to function. That is his allegation in the writ petition.
What is the joint charge has been handed over as the headmaster?
My lord, that is the allegation in the writ petition. That is the averment made in the writ petition.
Mr. Bhattacharya, we are wanting to know in terms of the DI order. DI order was twofold. First is you should be allowed to function as assistant headmaster, and second, the ADR claim which you have from the date of appointment that is not to be paid just now, subject to the result. Now we are wanting to know whether you have joined after which is the date.
The exact date I cannot say, my lord. After the order was passed by the learned trial judge in July 2024.
Then
July
you implead,
2025.
then Mr. Bhattacharya, you implead this Farooq in your writ petition and let it be heard out on merits. What is the problem? You have got the initial benefit, and whatever steps are being taken will abide by. You're challenging the writ petition that why will you not give me the ADR salary, which you have stopped. This is
No,
your
ADR salary money is on the process. It is being calculated, and as per direction of the court, my lord, I am supposed to get the ADR current salary.
If your lordship kindly takes up the order impugned in this appeal, my lord, what is the submission? What is the observation? What is the recording of fact by this honorable court? Lordship may kindly have a look at this. Now, my lord, paragraph 8 of the
Paragraph 9 is the order directed to release the salary.
My lord. Function.
কোথায় বলেছে?
এই তো প্যারাগ্রাফ 8টা দেখুন না, স্যালারি দিতে এরিয়ারটা দিতে বলেনি, কারেন্ট স্যালারি দিতে বলেছে।
এরিয়ারটা আমরা অ্যালাউ করছি is hereby accorded প্রুফ করলাম ফ্রম 2015 এবং বললাম নো এরিয়ার ক্লেম ইজ টু বি এন্টারটেইনড আনটিল
He was not, he has not
court
challenged.
also.
He knows the order, he has annexed it here, he has not.
DI, when hearing was conducted by DI, he was not called. Since in your writ petition, you did not make him a party. This is a
That
fact.
is after approval, post approval, my lord, the consequences.
Approval was 2015.
Yes, according to approval, I am entitled to get the salary and joining. No, no one challenged the order of approval. Order of approval is not a subject matter of challenge at all.
That is in the other writ petition.
No, no, no. Here he has challenged the panel only.
Naturally, panel.
The approval challenge.
If the panel goes, how your approval will remain?
That has not gone, my lord. 2015 onwards till today, that has not gone as yet. No interim order has been passed therein. 2015. It is pending. Let him proceed with his own writ petition.
He preferred a writ petition challenging a one-man panel. Subsequently, writ petition, it was said that abide by the result. Finished. Now, thereafter, DI gave you the approval. As they were not implementing, you filed a writ petition. In that writ petition, you did not make Parvez a party, Farooq a party. So
that is already covered, subject to result of the writ petition, that he is protected with the interim order
exactly.
passed by
So
the court.
why didn't you make him a party? He could have said something to the DI or to the court. Now his lordship has given you the final relief. Lordship said writ petition pending, give everything.
Well, what the relief he can get, ultimately he succeeds, but it will prospectively that effect will be given. If his writ succeeds, my lord, at all.
Right.
That has not been, my lord, prosecuted by him even for the last 7-8 years.
This order from the DI you have obtained without making him a party. This is the problem. If he had been a party, he wouldn't have appeared. We won't have considered him.
Well, this order of approval was in normal course passed by the DI.
Right.
Normal course.
Thereafter, approval, you are not getting the benefit. So you came after 3 years. That give me the benefit.
Yes.
Court gave you the benefit without getting an opportunity to hear him.
Well, what the court he's hearing, well, is there any consequence of this?
How the court, that the court should consider, na consequence or no consequence. What is your argument?
What is the effect of such hearing? Well, he has not mentioned his matter for hearing even that motion of 2015. Mere pendency of a matter, my lord, will cause this prejudice to a person, my lord, who is armed with an approval of appointment by the DI. Subject to result, brother, that is there. If I ultimately it succeeds, brother, my appointment will go. But why should not I be favored with the benefit of the order or approval by getting my salary and getting my post? Ultimately, if I am to declare that no, your selection is bad, I shall go. Consequence will be covered by the that writ court.
Yes, what do you say, Mr. Gaji? এ তো অ্যাপিয়ারও করছে না, কি করছে?
I'm not hearing, my lord.
Has he, Mr. Prasad, has he understood what we are thinking?
Hello,
Have
he
you
is-
understood?
Now he is submitting that he is not appearing. Since
Not appearing for whom? You are not appearing for Farooq.
My lord, withdrawing it. Status of the final order is much suffering, my lord. Status of the final order. As because it is interim stage, my lord. Interim stage, the final order has been passed.
এইভাবে মামলাটা করতে পারেন না
বুঝলেন, আমি না
হ্যাঁ এটা পরিষ্কার করে বলুন আমি
You know, if you ignore this fact that you have repenting such and such, what is your argument or submission on merits?
জিজ্ঞেস করছেন তোমার এই স্কুলের হয়ে অ্যাপিয়ারেন্স বা এই ফ্যাক্টটাকে
ও বুঝতে পারে, জানে ভেটারেন লয়ার রাজশ্রী, ও ভেটারেন লয়ার, ও সব জানে।
না
অনেক
মেরিটে
মামলা।
বলো,
জানি না
মেরিটে বলো,
না জানি
অ্যাপিলের মেরিটে মাইলটকে বলো।
My lord, appeal status, my lord, is in an interim stage, my lord. And in an interim stage, the final order is has been passed. The order has been forming as a final.
So, as an interlocutory order, final relief has been given.
Final relief has
It is your contention.
এটা তো ঠিক যাতে মাতাল তালে পায়
status of the final order is suffering.
যদি ক্লিয়ার হতে সিরিয়াসলি করে
নো, এইচএম স্যালারি দিচ্ছে।
No.
Yes, what
My lord, that is under process. That is my instruction. My lord, that is there. My lord, that is there. He is not. My lord, the pay fixation, that part the department is.
that is for the area.
My lord, I understand. My lord,
Why the school has sent you requisition as a assistant headmaster? Has the school done so?
my lord, to that effect, my lord, I will
Letter
take
is there of
instruction.
the school.
Letter is there, my lord. There is an
School has sent
indication.
For releasing current salary or
My lord, the communication of the school says you are to the concerned DI, you are therefore requested to fix his pay as the HM so that he can get benefit at an early date. My lord, my lord.
Automatically processed.
That technical part regarding embargo of my learned friend, regarding appearance of petitioner as well as school authority, then your lordship kindly, my lord, takes up all these writ petition along with appeal, fix a date and hear out the matter. We will file our opposition before your lordship.
We will take the
if there is a loss of forum, there may be
Since your lordship has,
We will take this one.
since your lordship has intervened, my lord,
loss of forum.
my lord.
It has not preferred any appeal.
No, my lord, we have not.
You comply with the order. Why?
No, no, we'll come. We are
No,
in the
one-
process
one
of
thing-
compliance.
One thing, one-man panel was prepared,
My lord,
and the person was giving appointment to the post of assistant headmaster.
my lord,
Now another person has challenged the same.
my lord.
This challenge, no decision on this challenge has
No.
been taken.
No interim order. even.
Maybe interim order is subject to the result of the writ petition. In the meantime, the person who has been successful, he has come, making him not a party.
Now, in the
And he
meantime,
is
approval
getting
was granted. He challenged the panel.
he is seeking permission to allow him to function and give him salary with area. Now all relief he is getting. Now what this man will get? If he finds a justified claim, maybe we
This
don't
man
know.
will get when the man's person writ petitions will be succeeded.
Mr. Bhattacharya, you have joined today.
No, I joined on Monday.
Oh.
Tuesday. The man's relief lies on his own writ petition, his
Mr.
own claim.
Bhattacharya, Mr. Bhattacharya, we will allow the leave to appeal and we will hear out the appeal.
My lord.
We will say that the single judge's order towards allowing him to function as AHM should be complied with DI. Pertaining to the ADR claim, that is a subject matter of the writ petition, you come with us on affidavit. Either you come before us.
I am bow down to your lordship. Current salary being paid.
Yeah.
As AHM.
এখন
I am agreed to this.
এখন ঘুরেছে।
The payment
না না area salary দেবে না তো এখন
you function.
হ্যাঁ
Mr.
current
Bhattacharya,
salary from the date
you
of
function, payment of your salary, current and area will be decided.
decide current I will not get. I am working as a resident headmaster, sir.
ও কাজ করুন না, কারেন্টটা দিলে আবার salary, your pay will be fixed.
From the date of
Then
court's
if
order.
you find that the one-man panel, preparation of one-man panel was bad.
There is no bar in
then
preparation of
again
one-man
defeats.
panel for resident headmaster.
There is no bar.
There is no bar under law.
আমরা বলে দিই, এটা entertain করলাম, okay, liberty get yourself added in the petition and make appropriate application.
লর্ডশিপ যা বলছেন ও বুঝুক।
ওটা fixation of salary, how can we direct at this stage?
The current salary, I have been approved. I am an approved teacher. I am an approved teacher.
The fixation which will be made, current salary fixation will be.
Current salary will be current from the date of court's order. The lawyer of such a person who is acting in both the way, if the appeal is not maintainable, Lordship grant them liberty. I have no objection to this. But let Farooq come with clean hand. In Farooq's writ petition, this person who appeared for the school. I can understand the Farooq does not know. No, it is not so. In the writ petition filed in 2015 by Farooq, these gentlemen appear for the school.
We are disposing of everything. You will get your current salary. We modify the order. We dispose of the leave to appeal and stay application. Go to the writ court and get the final order.
Current salary to be fixed from the date of the order of the trial court.
Then
yes.
From the date of the order of the trial court. I am not praying that
when you started functioning as a
yes, as per the order of trial court, the court said you allow him to function. Court may not punish me in that fashion. At least court's order should be honored by the division.
We are not so powerful that we will punish you.
Yes. Yes.
The gentleman get it from the order of the trial court. That is not a subject matter of challenge as today only. Approval order is even not a subject matter of challenge. 2022 approval. I am not paying the notional fixation for 2022.
Litigation must end. Your approval was from 2015. You have already suffered for 7 years. Today, you came for implementation of that order. You yourself sat quiet for 3 years.
2022 approval is given.
So, you get your, we will say you will get your current salary as headmaster, assistant headmaster. But so far as the arrear claim, that will be decided by the single judge. He will make an addition of party application. Both the writ petitions will be taken up.
Both the writ petitions are taken up.
No, allow করলে না just leave to file allow করছেন না. The Lordship is not allowing the leave to
unless we allow how we can pass.
So I am putting a question to myself how this leave to appeal application is maintainable at the instance of Mr. Ali. I have taken a specific point. This learned advocate, I have shown your Lordship the order where he appeared for the school.
Show your no objection na. Yes,
my lord. It's not at my. I have given to the school, my lord.
Huh?
I have given to the school money
in respect of what matter? Two matters, both the matters you for the school. In both the matters, your Farooq's matter you appeared for the school. My matter you appear for the school. So casually they are taking the court to. Let him withdraw, my lord. Let him come with a fresh writ petition. Fresh appeal.
Yes, what do you say to that?
Yes, my lord. I am not into this matter, my lord. As because I am not appearing into this matter, my lord.
I am not appearing in this matter.
As because there is a question of balance, my lord.
Have you understood what you must have understood? What is the problem? This is not. We find it not proper on your part. Your presence, one matter. How does it matter to you? You are practicing for so long.
25 years, my lord.
Then
তুই ওকে ইংরেজি বোঝাচ্ছিস।
Objection.
হচ্ছে senior.
You file afresh. We are disposing all everything.
Mr. Gadi, learned advocate appearing for the
But I'm appearing on behalf of the appellant, my lord. On behalf of the appellant, my lord. But
Who's
the
opposing you?
Lord, we are opposing, my lord.
Oh, yes, sir. Tell us.
My lord, the fact, my lord, here is the appellant before your lordship, my lord, qualified the 2014 TET examinations, my lord. Thereafter participated in the
2012.
2012, my lord. I'm sorry, my lord. 2014.
2014, man.
14, my lord.
14.
Subject to correction, my lord. 2014, my lord.
So in page 29, why it is said TET?
She applied, my lord, in 2012, thereafter again in 2014, and then was qualified, my lord, in 2014, my lord.
Very good. Then,
my lord, thereafter, my lord, she participated in the recruitment process of 2016, my lord, which is before your lordships, my lord. Thereafter, my lord, she was not told about her candidature, my lord. She did not know anything. Thereafter, my lord, in the year 2023, my lord, she took out a RTI application. And thereafter, my lord, she came to know that she was successful in the 2016 process, my lord. Be that as it may, my lord. In the year 2020, my lord, in the month of December, my lord, there was another recruitment process of 2020, my lord. She could not participate, my lord. So
she did not
participate, my lord. I have taken instruction, my lord. Thereafter, my lord, she took out this writ petition praying for participation in that particular process, my lord, of 2020, my lord.
Of 20?
20, my lord.
Being a TET 2014 qualified.
My lord, yes.
But court said that you cannot be allowed to participate in the panel which was prepared has already expired.
My lord, yes.
Then what is the wrong in that, sir?
My lord, I've come up on
You now want to be accommodated on the strength of your 2016 result. Is that your prayer? I don't follow your prayer because your writ petition prayer is kindly come to page 24.
My lord, yes, sir.
You're saying to fill up the remaining vacant such
That
and
was
such.
subject to correction, my lord.
Terms of notification 23rd December 2020.
My lord, that was the 2020 process, my lord.
That is
was
2020 process.
2020 process, my lord.
But 2020 process, your life has gone.
My lord, yes. My lord, yes.
Then, sir, what? How can we help you?
Come upon, my lord.
How can we help you, sir? Tell us. We pass order or you withdraw?
My lord, there's no instruction, my lord, in regarding of withdrawal, my lord, from the client, my lord.
Then we will pass.
My lord.
The present appeal has been preferred.
happened in 2022.
No, my lord, that's
You said that was the that.
But I tell you, I explained to your lordship, I avoid to, my lord, that particular my submissions on behalf of the board. If
Let him come and tell us he does he come within the zone.
my lord, this is not the scope
No,
of
no,
the.
we will argue. You will argue that even if he comes, this writ petition does not warrant issuance such an order.
Well, that's why I'm making your lordship today.
Today we are asking you, Mr. Shandal, then what was the cutoff? Which category and which medium you appeared?
My lord, general category, my lord.
Bengali medium.
Bengali.
Bengali medium.
General category, Bengali, my lord.
General category, Bengali.
District-wise, which district? Howrah.
Howrah district.
So many questions will come up.
সেটা যাই না।
Now, no pleading, nothing.
Total marks 50. 50 training. Training, how much marks? Training.
Training 15.
15. So without training, untrained, how much it comes to? Total 50 minus 15.
50 minus 15.
Which rule is it as?
12 out of 12.856 out of
50 minus 50.
out of 50.
No.
Yes,
35 of it.
Out of 50. Out of 50.
No, 50.
Mala total 50, including 15.
No. If 15 will not apply to him. So
absolutely.
His total will be 35. In 35,
but he's Malad, I'm just Malad, just Malad 50, including training 15.
Right.
So he has to contest 50. Out of 50, he has got 12. Out of 50, he has got 12.
No. His evaluation will be without the marks for training.
Without the marks of
later, what is it? Total marks was 50. If he is an untrained candidate, he does not get those. That 15 is excluded. So total marks comes to 50 minus 15. It comes to 35. In 35 assessment, he got 12.86.
Malad, out of 50, he got 12.5. Malad, just Malad, all were Malad considered against 50. But
untrained, trained.
Trained,
That was
untrained,
16,
all.
16 was untrained will be assessed on the basis of academics, TET,
except training.
Except
training.
So that is 15 marks.
That is 15 marks.
So out of 35, the marks was given.
No, Malad, your lordship is looking this way. Malad, the rule says, Malad, all were considered as 50. But they have not get the Malad 15 marks, training marks. But they were considered against 50.
Whichever way you
Malad.
So this was Bengali medium.
Bengali, my lord.
দিয়ে দাও তাহলে।
So by that order, the petition preferred by the appellant was dismissed. No.
Section 5 is there.
Section 5 is there.
There is a delay of.
As we have invited the party
86 days delay, my lord.
to advance their argument on merit, the delay in preparing this appeal
You got a bad client, Mr.
is content. As can such and such is disposed of.
জানি না this is জানি না কি করলো এই অ্যাপিল গুলো তুলে দিই
দেখি তো
Yes, so this is that matter. Mr. Shambhuddha Datta, my lord, he is the advocate on record for appearing for the appellant. It is state appeal. My lord, this is that matter, that higher scale of pay in physical education. My lord, is at that before vacation, it was taken up by your lordship.
Yes, yes.
And there is another matter, my matter, it's item number 23 in the list today. My lord's desire is to take up these two matter analogously. My
Then
lord,
how your appeal survive? We have held against you. In another matter, we have held against you.
regarding physical education, my lord, let it be then only making prayer that, my lord, let it be not this week, because the advocate on record is ill for the time being. He'll come in the next week if any day. And my lord, my lord is in the another matter. Just I want to know from your lordship that in the another Bokul Singh judgment has been followed. Is Bokul Singh?
Bokul Singh was there, and the Utpal Koro.
Yes, my lord, but there are some.
So you tell us now what are some. You
My
are
lord,
not telling us what
no,
we
no,
are
then,
repeatedly
my lord,
adjourning.
only then I have to place the.
To place it, come ready and finish
Yes,
it
yes,
off.
then let it be next, my lord, because he is the advocate and record. I am not the because my lord has.
You also said that it is covered, but he said that no, I have one point, I will guard.
Yes, yes.
So this is we adjourned it as a last chance. You don't know that.
No, my lord, it is not because he is the advocate on record.
Which is your matter? 20?
My lord, 23.
23.
Yes, yes, 23.
23 টা করে নাও
Yes, sir.
item number 4 23 করে নাও 4 টা তো আলাদা
Because in this matter, my lord, this physical education.
তাহলে 23 আর এইটা next Monday রেখে দাও.
23 can be taken. 23 let it be remain in the list.
It will both will appear on next Monday. This one as well as 20.
Not identical matter.
My lord, in 23.
23 is separate.
The higher pay scale issue is involved, but we are not, because he is entitled to that effect because it is an honors PG. He improved in that.
Oh, then why did you
my
prefer
lord has at that point of time, my lord, it is my lord desire.
Let it remain.
Let it be remain. My lord, it can be disposed of.
It is not this week. Inform Mr. Dotto that we cannot this repeatedly do this. Yes, next.
Well, this is that matter, physical education, higher scale of pay.
You are for the writ petitioner. Who is for the appellant?
But appellant is Sanjeev Datta.
Sanjeev Das.
Sanjeev Datta or Sanjeev Das, na? Sanjeev Das.
So come on Monday then. Next Monday. Yes, next.
Your Lordship, on a similar footings, my lord, your Lordship has decided this issue, this division, if I am not wrong.
Yes, yes. But in the item number 5(4), he said that we told him. So he said, no, there are 2 or 3 points which we must argue.
Now here, the only point has taken delay. That is why your Lordship, my lord, asked me.
Are you there, Mr. Prasad?
No, no.
Yes. Who is appearing against you?
Sanjeev Das.
Sanjeev Das. Why is not here?
Only the limitation point has been taken. Your Lordship granted leave. Bring it some records, my lord, that you have applied. I have applied. I file a supplementary.
Next Monday. Yes, next. Oh, tale. Mr. Prasad, that earlier one that will also appear on 2nd.
Yes.
Monday is a combined list.
Yes, my lord, second.
Yes, next.
Please, your lordship, kindly seize your lordship's previous order.
Before my learned friend start, my lord, there is a difficulty. Mr. HON'BLE is appearing for the state in this matter, my lord. He has not brought it
Let him not bring his brief, my lord. He has to file an affidavit in terms of your lordship's order. This is that, my lord, Kollani matter. They are merely taking time. The principal secretary and the registrar of the university were present in court before the coordinate bench. The coordinate bench insisted that they sit over the matter and give a detailed report. But kindly seize your lordship's order on Mr. Sen's prayer. My lord, it was adjourned till today, and 14 they were supposed to file an affidavit.
You have not yet filed.
No, my lord, my instructions, my lord, are not yet filed, my lord. One day accommodation I am seeking, my lord.
Sir, how many times we let?
I know, my lord, I know the difficulty.
That's embarrassing for the court, na?
On Mr. Sen's ground, my lord.
Second day, Mr. Bhattacharjee.
2nd December, I am in difficulty. Kindly keep it tomorrow, because they are to use.
Mr. Bhattacharjee, again this prayer will be made. Mr. HON'BLE Sen is appearing. So he usually in his matters
No, my lord, he usually appears and assist, try to assist, my lord. But today, my lord, I learned from his clerk, my lord, the briefs and all.
You are not there on second.
Personally, I am not there in second. Second, is not the issue.
On third. Next. But please don't take adjournment.
This is, one sentence order be passed that this last direction is peremptory by 3rd. 14th was the date. They have not used an affidavit. Since your lordship is postponing till 3rd, let it be understood by 3rd something is going to come.
Why you are insisting? We must have some sort of reliance on the advocates who are appearing. When he says that if he doesn't come, you remind us, we will proceed accordingly.
Your Lordship, on behalf of Dr. Patro,
7 are for the repetition.
appearing for the appellant, my lord, I am praying short pass over. Item 7, 8, 9, my lord. Dr. Patro is arguing before courtroom number 17, my lord. 4 matters are going on, my lord.
Yes, Mr. Bali.
If he wants pass over, let him pass over.
Not today.
Your Lordship, item number 8, I am for the appellant writ petitioner. May I place the facts? May I place some facts? I am led by Mr. Ashish Kumar Choudhury. Item number 8.
Item 8 is similar to 7, no?
No, not similar.
Your method is 7.
7 and 9.
7 and
8, 9.
7, 8, 9.
Appellant, Dr. Patro appearing as appellant on behalf of item number 7 and item number 8 for the respondent school service commission. And again,
then let us take up 8. Let him argue what is there. 8, 7 and 9 not today. Yes.
9 টা তোমরা appellant তো নাকি?
Yes. Item number 8. Your Lordship, may I place the facts? The petitioner is the untainted teacher who lost her job in terms of the Supreme Court order.
Yeah, please. Which
2006
page? Your stay application? Which page? Your order?
Order is at page, Your Lordship.
13 June 25.
No, order is on 11th August 2025.
Page 11th August.
It's volume 2, page number 153. Page 153.
Yes, sir. How can we help you?
Lordship, as she was in-service teacher, she was not allowed to participate in the interview and counseling process in upper primary.
You did not allow. You did not appear.
Yes, I
Personality
appeared,
test, you failed to appear on the ground of ailment.
but Your Lordship, similar matters were moved before Your Lordship, where Your Lordship was
That to
kindly
be
fixed.
directed, give appointment to some.
No, Your Lordship, these are the orders. Your Lordship has fixed these matters on 4th. Kindly fix this matter analogously and kindly heard it.
Yeah, they have
Yes, sir.
used the opposition.
This is the first time it is appearing, but similar matters were moved and this order was passed by Your Lordship. Same order was challenged.
No,
Like
in this matter, we did not.
contention was same in the matters.
Oh, similar issue is
Similar
fixed to
issue,
be
yes,
considered on
yes,
4th.
yes, Your Lordship. That is why kindly fix this matter on 4th and it
But
can be heard
the
analogously.
matters we have fixed on 4th. In that case also, though they did not appear in personality test. Are you sure?
The order was passed by Honorable Justice Shogata Bhattacharya. The contention was same. The order was similar. The petitioner is just different. Grateful.
Lord, I'm appellant, my lord.
You're for the appellant?
Yes.
Your service is complete?
Yes, my lord. Fine, my lord. My lord, yes. Fine, my lord. Every such. My lord, into the order, my lord.
Yeah, let us go through the order.
My lord.
5th of August order challenged.
My lord, yes, my lord.
Daughter expired.
My lord.
Father is wanting family pension. Do you come within the daughter was a married daughter?
No, my lord. Unmarried daughter. Mother predeceased.
Mother predeceased. Your father, what was your father doing? He was
No, my lord.
he was an unemployed.
Representation was made.
But family pension, your entitlement show under the
My lord,
DCR.
my lord. My lord, 11 portion I have, my lord, my lord. My lord, West Bengal के service के death काम के retirement के benefits rules के नहीं. My lord,
No, this is West Bengal. 71. Why 71? 81 scheme is there. 85. PCRB. Why West Bengal services? আরে এটা তো অ্যাপ্লাই করবে না স্কুল না DCRB scheme will apply 81 circular আবার বলে মাইলর ওইটাতে প্রভিশন এটাই আছে
parents my lord
দেখি ওই হেডমাস্টার ম্যানুয়ালটা how this will apply Mr. Maiti, how this will apply?
Well, this is for state government employees. বসো বসো
Where is that?
সাইডে বসো।
আরে 85 স্কিমটা কোথায়?
Pensioner heading as by women, deep roots, canteen, qualification.
এই যে পেজ 1089
1089.
1087 থেকে আর
দিয়ে দিন না দাদা,
Family,
বসুন, কোনো ব্যাপার না।
যেসব ফ্যামিলি পেনশন পাবে কি করে?
Parents, my lord,
এটা ওকে দেখো। You have another pension you got.
Yes, that is admitted.
Unfortunately, you expired. See the definition, entitlement of family pension.
Family
Right hand side page. Yes.
for the purpose of a family pension.
my lord, this my lord, 5 my lord, dependent parents. My lord, parents mean my lord, father and father, either mother. My lord, this is the my lord, my responsibility, my lord, 5 my lord. My lord, kind my lord, this is
Family
parents.
pension. Family pension. The
Yes, but for purpose of family
pension,
yes, tell us who are there. Who are there? Read from top.
My lord, for the purpose of family pension.
No. Family includes the following relatives of an employee. One টা omit করুন, two.
Two my lord, my lord, clause 5.
এই ডিপেন্ডেন্টটা খুব করতেও তো মাথা খারাপ হয়ে যায়। Dependent. Pension নেই, whether or dependent ছিল। Question of fact. চলে যায়।
Where did you make the representation?
My lord, the presentation was minimal, on page 25 my lord.
25 কিসের?
Yes, Mr. Basu, he comes now. Appointed 30.
No, my lord, subject to your lordship's approval, my lord.
Dependency has to be gone.
Yes, mere saying that the father is a dependent upon the deceased daughter, my lord, subject to your lordship's approval will not do. That has to be substantiated.
Yes.
Yes. So, my lord, there is, yes. So, my lord, I have to take instruction, or otherwise district inspector of schools will pass a reasoned order, my lord.
Much to put as a thing.
My lord,
nothing.
only my lord, 3 members, mothers, deceased my lord, the
Where you have stated that in your representation?
my lord, Nivedwal was appointed 30.
Now pension was also not disbursed.
Pension, only the gratuity amount already disbursed.
Gratuity given. You expired on 5th of April 23. It was a died in harness. No,
Yes,
how? You got gratuity, that is after retirement.
No, my lord. My lord, died in hand.
Died in when did you die?
My lord, died on
Died on 5th April 2023.
5th April 2020.
Before her, when was your date of superannuation?
Date of সময় 9 বছর।
My lord, she died at the age of 38.
30. My lord, death certificate, my
9 years, 3 months, 24 days he rendered service.
22. My lord, death certificate 22. Page 20.
Then you do not become entitled to pension.
9 years of service.
10 years qualifying service is required.
Yes.
So, my lord, in the death case, my lord.
No.
Pension.
পেনশনের এন্টাইটেলমেন্ট হবে না, পেনশনের ডেথ গ্র্যাচুইটি ওটা পেয়ে গেছো তুমি,
পেনশন পাবে।
ওটা দাওনি কেন? 5 লাখ yes. Admissible death gratuity and other benefits. Petitioner family
Where
pension.
is your PPO?
My lord, kindly, my lord, PPO, my lord, page 24.
Page
24.
24. এই যে 24 এ দেখো কোয়ালিফাইং সার্ভিসটা কাউন্ট করেছে।
Pension,
5 years এ গ্র্যাচুইটি পাবে।
family pension.
Then how can you get family pension?
My lord, in case, my lord, normal, my lord, retirement, my lord, in case to the death.
It is not a normal year. You expired prior to your retirement. So rendering 9 years of service. For those 9 years, minimum service for gratuity is 5 years. So you got the gratuity.
কেন এন্টাইটেল নয় এই গ্রাউন্ডে গ্রাউন্ড হ্যাঁ রুল ইন্টারপ্রিটেশন, কিন্তু ওর অ্যাডমিসিবল সার্ভিসটা হয়নি ডিপেন্ডেন্ট প্যারেন্টস।
Oh, 23. 23 first.
23 the family pension. After ending at least 1 year of service, family pension is admissible to a member of the family who dies while in service after ending at least 1 year service. এটা খুবই সিম্পল, ইয়েতে গভর্নমেন্টের ক্ষেত্রে কোঅর্ডিনেট হচ্ছে গভর্নমেন্টের
আর কিছু রুল আছে, আর কিছু আছে? এটা তো ওইটা নিয়ে এসছো কেন, যেটা স্টেট গভর্নমেন্ট এমপ্লয়ীদের ক্ষেত্রে এন্টারটেন। তোমার কি ইয়ে ছিল ডিএ গেটিং স্কুল?
সেইটা যে হিসেবে
এমনি স্কুল মানে
50% of the last
স্কুল
to the maximum
প্রাইমারি সেকেন্ডারি সেকেন্ডারি
সে 7 বছর ইয়ে করলে ফুল পেনশন ফ্যামিলি পেনশন। পুরো একটা বিশেষ
হ্যাঁ ডিস্ট্রিক্ট ইন্সপেক্টর স্কুলস আর অ্যাপ্রোপ্রিয়েট। আর ফাইন্যান্স ডিপার্টমেন্ট কি করবে?
You are for the DI also?
Yes, my lord, I am for the DI, but the concerned respondent, yes, only DI. But the other officers, my lord, subject to your lordship's approval, implemented in the red petition as well as the finance secretary, pension provident fund group insurance, they are probably
No,
not the approved.
it is not that he is not entitled. He's entitled.
Yes, my lord, yes, it is otherwise. Because of this, yes, my lord, but that is not indicated in the order impugned.
Order does not give any reason.
Yes. Only says there is no rule, but the interpretation and the definition of family pension, that is there. But my lord, the qualifying service, that will.
No, qualifying say kindly come to clause 23 of the এটা okay দাও। Family pension entitlement will come even.
Yes, my lord.
ডিপেন্ডেন্সির কোশ্চেনটা তো ডিপেন্ডেন্ট ছিল কি ছিল না?
The present appeal has been preferred, challenging an order dated Hey, Mr. Maiti, take back your.
Item 11 is my appeal, my lord. It is the state.
একটা কপি রেখে একটা রাখা আছে তো?
My lord, kindly see the last order, my lord. The interim order is persisting, my lord. Pursuant to the pendency of a matter in the Supreme Court, my lord. The matter is still pending, my lord, to be taken up on 15th of December.
No, that has nothing to do with us.
No, no, my lord. That is there
We are not
recorded.
part of that matter.
It
This
is up-
argument has been raised by the state and they are
No, no,
dragging
no.
this.
State did not raise this argument.
So why didn't you urge that at the time it was initially extended?
Well, we had stated we are not part of it. When this, I'll tell my lords, this point was first raised before
order
Honorable
was
Justice
passed.
Rajseka Manta, exactly on the date when he was passing the order. He asked us, we said specifically, it has nothing to do with us.
Which one?
Well, this argument that matter is pending before the Supreme Court.
That interim order was granted initially when?
7th of August, my lord. That interim order was on merits.
My lord,
Thereafter, my lord, we filed a affidavit where from the division bench found that we have filed identical affidavits before the Honorable Supreme Court of India. And therein a contempt application was pending. So the division bench found it fit not to take up the matter till the contempt application is over. Accordingly, my lord, it has been coordinate benches, my lord, has passed, extended the interim order and adjourned the matter. And my lord, that particular contempt application is now to be listed on 15th of December. This is the case, my lord. We never made any submission. We had filed a report, my lord. I can show it from the orders. In that report, while perusing the report, the division bench found that there is a matter which is interconnected and an affidavit.
Where is that order?
My lord, I will assist, my lord. My lord, will kindly take up the order dated 17th March 2025.
Read the order.
17th March 25.
My lord. এই matter.
না, এটা জানি এই matter. The report revealed that the committee constituted by the state government by notification.
order My lord, will kindly take up paragraph 4 of that order.
Well, this is a submission, my lord. It's a mere submission of the state.
No, we did not. It is
Please give us an opportunity to
revealed from the report. Judgment জানতে বলছিলাম এনেছে বসুন যা বলতে বলি বল
Yes, Mr. Chair.
Well, it is there in their report. State had filed a report. They said the matter is connected with the matter with the Supreme Court. There was no direction to that extent. Paragraph number 4, if your lordship kindly take paragraph number 4. What is it? It says that the report further revealed that an affidavit is also filed before the Honorable Supreme Court of India in connection with WP number such and such.
So why? What was the earlier resolution adopted? Reservation.
My lord, I will show from.
Let us understand. Department of Women has framed the West Bengal Transgender Persons Protection of Right
Rules.
2020 for providing equal opportunity. Then this committee, why this decision? Why this decision next so far as reservation of transgender?
Lord, for reservation, my lord, if my understanding
under these rules, under these rules of 2022, what is the provision for transgender?
No provision. So far I understand.
This committee has been set up.
Pertaining to the reservation,
Committee
so this question of reservation has not yet been decided by the committee.
Nothing.
Not yet.
That is the reason why the coordinate bench was of the opinion this matter should be heard and state should come up with the report regarding the progress of this. Because the original decision of the Honorable Supreme Court in the Nalsa verdict was pronounced in 2014 and we are in 2025, 11 years. My lord, by this time the state should have prepared their rules for the transgender reservation.
Mr. Chatterjee, the coordinate bench says that the committee would not be able to give the final opinion because if the contempt is dismissed.
My lord, I am asking this question to myself. The dismissal of the committee's decision, Supreme Court's or contempt application, will that change the position of law?
Certainly.
Which is already there because in 2014
They
the direction
will have
was.
no other option but to give.
Well, that now the
in the Nalsa there was a direction for reservation.
Yes, my lord.
That was not being followed. Contempt
But
has
in
come.
respect of that matter, but so far Supreme Court has never stayed that order.
But Mr. Chatterjee, this order was passed in your presence. Now it says Supreme Court is in session on 15th.
My lord, this order was, they have only this order, kindly see, it is only recorded their position in the report, nothing else.
No, we have been informed.
Lordship,
Since the interim order passed is operative, we extend it.
no, Lordship, that prior
What was the interim order?
interim order was that kindly that
was a
this
stay
matter
of the order of
stay out
Justice
for the
Manna
purpose
for
of
10
hearing.
days.
For
And
the
my lord,
purpose
on
of hearing.
30th of April,
Lordship,
my lord,
kindly take one by one
pick up the
all
order of
orders.
30th of April also.
This is one strategy adopted by the state. They will go and say that we are for transgender. Here they will oppose.
My lord, it is not so. My lord, will kindly take up the 30th April order, the next order which was passed by the division bench. There, the categoric mention of the contempt is also there. The court
But
had
their
sought
stand was, my lord,
instruction from the learned
No,
government.
then what is your stand? Since the contempt is pending, if the contempt fails, but the verdict of the Nalsa case remains.
In my understanding, my lord, though I do not have the briefs of the Nalsa judgment, the Nalsa matter to assist the court, my lord, here, the difficulty is after 2014 judgment, there were series of applications which ultimately came to an end in 2016. After 2016, my lord, there were fresh applications under the Contempt of Courts Act. And that matters are still going on, my lord. Orders are being passed.
What was said in Nalsa? Reservation issue was decided.
My lord.
So when you are not following the reservation issue, allegedly contempt has been filed. You are saying that committee I will not consider till it is ascertained that whether the contempt succeeds or not. What will be the effect in contempt? It is a contempt jurisdiction is pertaining to the person who has violated. The provision which is being violated, that provision has attained finality. So what prevents you from giving that?
I have understood what is falling from but what had
the order passed. Order is against you. That has attained finality. Now, question of contempt or no contempt will be taken up by the state in respect of the respective officers who were concerned. That why you are not complying. So that compliance also would be subject to a report of the committee. But you say I am not doing anything, contempt is paying. This way it cannot be.
The state has certain issues to be placed before the Honorable Supreme Court.
But may I make one submission? Because I have independent appeal against this.
Against this means?
My lord, against the order of the learned single judge. May I take your lordship to the Supreme Court judgment, one paragraph?
Tell us now, what is that?
My lord, page 123 of our paper. I just read out to the operative directive portion penalty made. 135.3 paragraph. We direct the center and the state governments to take steps to treat them as socially and educationally backward classes of citizens and extend all kinds of reservation in cases of admission in educational institutions and for public appointments. My lord, I can understand educational institution admission. For public appointments, my lord, covers all administrative.
For whom?
I'm for the board. And as well for judicial service also. Not only teacher.
Everywhere.
All public appointments. Executive, judiciary, everywhere. Lord, I have not come across any such rules anywhere extending these benefits to everywhere. So state is really in a soup to execute this order. Kindly visualize the magnanimity of this order. Now here, your lordships, I find the petitioner himself, I don't know himself, he belongs to OBC B category. He applied in the recruitment process in 2022 as OBC B. Kindly see the order. Treat them socially and educationally backward classes. He already belongs to that category. Now, one may argue that amongst the OBC B, there must be another class reserving 1% for transgender. I don't know, my lord, how much this is possible, class within the class. She applied. She could not succeed as OBCB in the selection process. Then came up before this honorable court. Now, my point is that in my independent appeal, I'm the board. I follow the rules, whatever they were framed by the state or the NCT in accordance with law in the selection process. He participated in the selection process, could not succeed by going according to the rules.
What has been the fate of that appeal, in your appeal?
Well, that's pending before your lawsuits.
Before
I beg to submit my lord.
Therefore, your lawsuits kindly, while my lord, the learned single judge, while my lord taking up, this point was raised that this has to be 1% reservation for transgender. The learned single judge first direction was upon the state. Give 1% reservation. Here my point, in the selection process which has come to an end, can there be a reservation, retrospective effect? Second, your lordships, in the same...
This committee was constituted on the basis of the single judge's order?
No. On the Supreme Court's order.
Oh,
Then second direction of the learned single judge upon the board to appoint him as a reservation 1 category. Well, how is it? The entire order is against the law.
So who are the contemners there? State authorities.
State authorities.
State has no information on this, my lord. Kindly, hear me, lordship. Mr. Sanyals.
Many other states, including the state of West Bengal. My lord, in my understanding, my lord, the committee which was formed in terms of the order passed in the Nalsa judgment, that committee's action is under the contempt before the Honorable Supreme Court, which is pending. That was the reason, my lord, it fell from the Honorable Division Bench, Coordinate Bench, that there should not be heard until unless it is disposed.
No, this was pertaining to which recruitment process?
22.
2022.
And that has come to an end.
My lord, if Mr. This is opposed to the stand taken by the Chief Secretary of the state. Lord, you kindly come to page 138. I don't know how come board contradicts this decision
Well, I am
taken by the Chief Secretary. Let it be. Kindly come to 138.
No, Mr. Chatterjee, how we can decide the issue which has already been decided, and the authorities are facing contempt.
Lordship, authorities are not facing contempt on this issue.
Whatever may be the issue.
We don't know what is there. It is the submission of the state. We have not got the report copy also.
Sir, why didn't you raise that point when the interim order was?
My lord, if I am,
it was not only before us, it was before
in that particular order, the Honorable Division Bench, in my humble reading, did not stay the proceeding on that ground. It was already stayed.
Read the order.
Yes, Lordship, kindly come to this.
17th March.
Paragraph 5, Lordship, kindly read. Paragraph 5.
Yes.
Kindly come to paragraph 5.
Of which order? 17 March?
17 March.
Yes. Read paragraph 4.
Paragraph 4 is there. Paragraph 4 is not the direction, Lordship. It is the recording. Lordship, may I read it once? The report revealed that the committee constituted by the state government, via notification number such and such dated 21 July 2022 held several meetings and discussed the issue pertaining to the reservation of the transgender community in the public employment within the state of West Bengal. In the meantime, the Department of Women and Child Development and Social Welfare, Government of West Bengal has framed the West Bengal Transgender Persons Protection of Rights Rule 2022 for providing an equal opportunity in the public employment. So far, the reservation of the transgender in public employment, either horizontally or vertically, is concerned, it is the active consideration of the committee which requires collation of the various informations and data. The report further revealed that an affidavit is also filed before the Supreme Court of India in connection with WP number such and such, where the competent contempt application is still pending. It is indicated in the report that because of the pendency of the matter before the Supreme Court of India, committee is not in a position to take any decision or issue any recommendation in this regard. In course of hearing, we are informed that the said matter is likely to be listed on such and such before the Supreme Court of India. In view of the above, let the matter be listed in first week of April under the same heading. It is not adjourned sine die in view of the Supreme Court's order. Supreme Court has repeatedly said that when there is a specific direction of the Supreme Court wants the High Court to have of its hand in a particular case, Supreme Court expressly stay that. But in this particular matter, this was a submission made by the state in their report that it is also pending.
The order of 7th August 2024. That was the first interim order granted.
Yes, ma'am.
Have you taken out any application for recalling that order?
No, ma'am, I want a hearing, the matter to be heard.
You have to wait then, Mr. Chatterjee. You cannot jump the queue. Interim order was passed in August 2024. And 8 times the matter appeared in your presence, the interim order was extended.
Extended considering the paucity of the time of the honorable bench, because the bench never wanted.
That is not the observation.
But
7th of August 24 order, interim order was passed.
We are of the view that matter would be taken up.
And you sleep on that issue.
No, we did not sleep.
Sure.
We are following the list every time, Lordship, we are following.
You don't come up with an appropriate
We are ready
application.
with the arguments, my lord.
Yeah,
If the state,
we are also ready.
if
But
the
the
state
Supreme
is
Court
not willing to give reservation to the transgender community, fine. This is the stand of the state, where Mr. Scannell is contradicting the stand of the chief secretary.
I'm not contradicting.
Yes,
I'm not
I
contradicting.
will show.
I'm appearing for the board. There was no reservation when you appeared in the selection process.
I will show from the record.
You never.
You have not done it. That is illegality committed by your association, institution, whatever, board.
December.
Board is not the law-making authority. Board is to
But
follow the
follow
law
the
made
law.
by the center or by the state.
So the board has nothing to say on this.
So don't
Let
pass any order.
act like board. Don't act like the government. But kindly come to page 139.
Sir, there.
Yes, yes. Fine. We have filed.
And in this matter, no paper book has been filed.
Paper book is there, if I'm not wrong.
Sir, there are 2 appeals. There are 2
Everywhere
appeals.
it is ready.
Eh?
Both ready. Paper books are ready. In both the matter.
Item number 11, 12. January copy. By records reveal
May I be permitted to take the opportunity to inform your lordships, the earlier matter your lordships in the morning disposed to your lordship wanted to know the cut-off marks.
Yes.
Bengali medium, that is 20, Howrah,
Sorry.
20.51.
Then why you are so agitated?
No, Malad, this should not be done, Malad.
Oh,
This is the scope of the
that is why the court is here and you are here.
No,
What
Malad,
should be
if
done
you
or not?
extend that, one has to come up with this.
Anyway,
That's what
he did not come within the zone of consideration.
Much better.
Reply to the
Judge.
Lord,
Yes, item 13.
13 minute I beg
ready
to
with
appear for the
affidavit. No, 13, I am for the appellant. The reply has got ready, but due to illness of the appellant, it could not be affirmed. That's why, 1 week time, not this, make it not this.
May I file our opposition at least?
No,
Plan for the appellant.
yes. Reply to them.
I'm paying for 1 week time to affirm the application.
Opposition, everything in opposition file on behalf of the state respondents is taken.
आगे ताले में इंस्ट्रक्शन
14.
14 valid, I appear. অবস্থায় কি আছে কত বেটা কত 14 তুমি আছো না স্যার নাকি তোমাকে দিয়েছি সাপ্লিমেন্টারি ভিডিও কপি হ্যাঁ এই তো
Mr. Dhol, you filed opposition.
to the supplementary affidavit, my lord.
Supplementary, Mr. Buddy, you have given?
Yes, yes. I have
Given?
supplementary, I have got.
Then you have received?
Yes, my lord.
Then opposition?
Opposition direction ছিল my lord, probably my lord, kindly extend some time, my lord, I will file up. This is my lord relating to compassionate appointment. My lord, may I submit one to it can be disposed of even without any oppositions. If the lordships, my lord, they are only the ground that I have crossed, I being a widow, at the time of making applications, the age limit is 45 in the compassionate appointment. And well, when I made an applications, well, when the death occurred, I completed 45 years, 9 months. But when I made an application, 46, 1 year, 2 months or 1 month is the time. But that's why the application for compassionate appointment was rejected. Although the fact-finding authority, Commissioner of School Education, if the lordships kindly takes up that their observations, that deserving can, but on the ground that I have lost my husband very early stage, but they cannot give appointment as I have crossed the age.
Show us any instance where it has been done, Mr. Buddy.
My lord, I shall be, my lord,
Otherwise, if how can we go beyond the rules? If you can show us that any judgment on that issue, we will consider.
I will place the judgment and also the relaxation clause.
Supplementary, you have filed the supplementary, Mr.
Yes.
Supplementary.
consideration, it requires to be released because your my lord was the order, my lord order in earlier proceeding. Withdraw করেছে? No, no.
No.
My lord, kindly have a look, page 30, 55.
I tell you, Lord. The order passed by Justice Mantri. Initial stage, one time the one writ petition was filed in connection. This writ petition, it was withdrawn. Your lordship is permitted to withdraw. Madam, there is no question of release for this.
Kindly have a look, page 55.
If it is withdrawn.
And that too, my lord, withdrawn without, my lord, any
very
leave
well,
from this
very
court.
well, that doesn't mean that your lordship has got no.
Page 55.
He's taking that point, Mr.
Is it a point?
On personal ground of one of
Is it the ground?
বিজ্ঞান ভাই একটা মামলা ফিক্স করে দিয়েছিলাম তো কবে মনে আছে তো পার্টিকুলার
I'm for the state respondent.
State, yes.
I'm for the appellant. Your Lordship, since Your Lordship have been instructed
Out
by
of time.
my senior that he is there in the Your Lordship court number 19 in a running matter. Get a pass over, Your Lordship.
Who is your senior?
Subhosay Chatterjee, Lordship.
Eh?
Mr. Subhosay Chatterjee, Lordship.
Service
Section 5 application is there.
507 days delay. Have you filed
Yes, Your
section 5? They have given copies
I have
to you.
filed the application, Lordship. Can 1 is the section 5 application. Section 5 allow for matter কিছু নেই 2006 selection process he has come before this honorable court after expiry of time 2025 2007 2007
Victor তাহলে বুঝি টাইম ছিল না
we delay down are already exhausted
বোধহয় আমরা বলেছিলাম যে রেকর্ডস পাওয়া যাবে
আপনারা এই করে
commission. Yes, what is the wrong in this order?
Since Your Lordship, the petitioner alleged Your Lordship that the petitioner secured Your Lordship 53.83 marks in Your Lordship the
You secured 52.83.
52 point Your Lordship 83 marks the petitioner secured, but Your Lordship the last candidate I mean that the candidate who was selected was the last candidate Your Lordship obtained Your Lordship 53.66 marks.
Wait-listed candidate.
Yes, Your Lordship, wait-listed candidate. But Your Lordship, so far is the marks concerned, Your Lordship, the petitioner secured more marks in Viva, in written examinations as well, Your Lordship, the other examinations except Viva, oral examination, Your Lordship. So that was the contentions. The other candidate who secured, who obtained the rank in within 12, Your Lordship, obtained more marks in Your Lordship the written examinations. In comparison with Your Lordship, the petitioners secured more marks than the 12 candidate who secured Your Lordship rank in the merit list. Only point is that Your Lordship that the petitioners got and obtained more marks in the written examinations as well, Your Lordship, the other qualifications that was stated there in the notifications. But in respect of the
Where
Viva,
is the list? Where
Your
is the
Lordship,
list?
that was
You have not annexed.
এটা আপনাদের রিপোর্ট থেকে
Where from did you get the breakup? This breakup of
May I
marks?
file a supplementary affidavit? Your Lordship, I have annexed the Your Lordship the list in which the chart is there.
Have you given copies to them?
They have produced the copy, Your Lordship. So
Show us the supplement.
yes, Your Lordship.
এই এদিকে একটা কপি দাও কমিশনকে একটা আলাদা কপি দাও
দেখুন
You have given 3 names. Physical education,
Krishna Majhi.
Page number 6 is the Your Lordship the list.
how
Chart
much did you
given.
get in written?
Your Lordship,
How much marks did you get?
in Your Lordship, Viva 18 is the P1,
P1 18, P2
P2
10,
10,
ACD 19, এগুলোর মানে বোঝা
na
যাচ্ছে।
additional marks 19, 52.83. Your Lordship, on the Viva 5.69.
Academic 90. What is QT? ACAD. Yes, Dr. Patru, what is ACAD?
academic score.
And what is QT?
Qualifying total.
Quality testing or personality testing.
Interview? Or
I check because
what is personal?
I think it is personality test. This type copy possibly has mistyped it.
It is PT. PT. So personality test,
It is PT.
PT, you got 52.83.
ওর থেকে একটু বেশি 21 আছে এইখানে ও 10 এই যে P2-তে P2-তেও 10 পেয়েছে
কোথায় এখানে
10 পেয়েছে। Part 2.
হ্যাঁ পার্ট 2-তে 10 পেয়েছে
Part 2 মানে written exam.
হ্যাঁ পার্ট 2-তে সবচেয়ে বেশি পেয়েছে কিন্তু এটা নয় যে পার্ট 1-এ কিন্তু ওর থেকে অনেক বেশি আছে আমরা 27
মানে অনেক বেশি। আর ওদের 52.83
কাটাকাটিটা কে করেছে?
ওইখানে 5.83 দিয়েছে যদি বেশি দিত ওই করেছে সীমাম করে
QT ওকে 5.83 দিয়েছে আউট অফ এ টোটাল অফ যাই টোটাল ওর থেকে তো উপরের জনই বেশি পেয়েছে।
আচ্ছা অন্যজনকে 6 দিয়েছে 8 দিয়েছে ম্যাক্সিমাম 6 দিয়েছে 8 দিয়েছে
এই যে 5.5 যে পেয়েছে সেও একাডেমিকে বেশি পেয়েছে বলে সিলেক্টেড হয়েছে।
qualified
What
beyond
is where is the list of 15 candidates?
12 candidates.
12 candidates, my lord.
No, 12 candidates first list, waiting list 3.
See. Now, that waiting list, lordship, we don't have the list. Perhaps.
এখানে this is where is the list of selected candidates which was
15
produced?
candidates, total 15 candidates.
My lord, there are total 15.
12টা হ্যাঁ
হ্যাঁ তো 12টার মধ্যে তো এ বাইরে চলে যাচ্ছে কৃষ্ণ মাঝি থাকছেন। It is qualified. Yes, where is the
can be done.
No, lordship, my point is the candidate who scored in under other headings, they better marks.
show us that.
Now, in page number 6A, lordship,
This is not the list. Before the court, they produced a list of 12 qualified candidates and 3 waitlisted candidates. That is what the judge records. In the impugned order,
yes, my lord,
the court has recorded that
that must be there. We have not supplied.
You were present, no?
We are present, but
Order was
that
in
was
the process.
submitted. Lordship, in impugned order, Lordship, if Lordship kindly come to the impugned order once.
Yes.
Lordship, it says the matter has been heard on number of occasions and pursuant to the order passed by the coordinate bench on 7 September 2007, this court directed the learned advocate for the West Bengal Central School Service Commission to produce the relevant records relating to 7th RLST 2006 for appointment of the assistant teacher in physical education in Bengali medium under pass category. Under pass category, today the learned advocate for the commission has produced copies of relevant records, which reveal that there were 12 vacancies for the post of assistant teacher in physical education under pass category, Bengali medium, for filling up those 12 vacancies of assistant teacher in physical education, and a panel of 12 candidates was prepared, and as per the norms, a wait list containing 3 candidates was also made ready. A copy of the wait list is produced before this court, from where it appears that the last waitlisted candidate secured 53.66 marks, whereas petitioner obtained 52.83 marks. Relevant part of the merit list prepared by the commission is also produced before this court. From the aforesaid facts, it appears that considering the marks obtained by the petitioner, she did not come within the zone of consideration for being recommended in the post of assistant teacher in physical education under pass category. Now, commission had produced 2 copies, my lord, which I have already enclosed with my CAN application, my
This
lord.
is not that. This is not
That was on the copy only which was supplied to us.
No, no, it is saying that 12 vacancies, 12 candidates.
Financial hardship and some personal issue there.
And it is 15, lordship. It is coming 15, lordship. That is, if that is to be considered as the list, then it has 15. Lordship, I will show from the record. Lordship, kindly come to my CAN application. Now, page 5, there are 3 names, my lord. Matters list of all applied CAN. Page 5 of the CAN application. Supplementary. CAN.
Page 5, yes.
Supplementary, my lord, page 5. Here, lordship will find 3 names. One is Nabura Ali, Ruma Adaf, Iti Babra. These 3 candidates under physical education, they are the district candidates as per district 2006 were assistant teachers. Then, lordship, kindly turn to page 6A. Lordship will find
12 names. 12 plus 3, 15.
15. Twelve names. And lordship, kindly see the candidate just preceding to my name, that is this Khaleda Banu. She got total 50.87, got empaneled. Just name immediately prior to my name. In total, she got 50.87. ক্যালকুলেশন ঠিক আছে তো?
এর থেকে কম।
এই ক্যালকুলেশনটা ঠিক আছে তো? ক্যালকুলেট করো আবার আমি বলছি।
This is not believable. Why will the court record that you got 52.83, that is telling, and the last person in the wait list obtained more marks than you, that is 53.66. That is telling with this list. Now, why this Khaleda Banu empaneled? We don't know that she was under which medium. Yes.
My lord, if your lordship kindly see the
page and type copy of the page.
Uh-huh.
My lord, I think, my lord,
This is not the least.
that is more than the, my lord, she got, my lord,
52.83.
and my lord, if original list, if you lordship kindly consider, then your lordship can find he got more than that. In original, maybe must be a type mistake.
Oh, it is 56.
My lord.
56 এটা যোগ করে দেখা যায় 21 আর 7 হচ্ছে 28
Lordship,
28
this
আর 21
calculation, Lordship, I
28 আর 21
have calculated
49
whatever is
আর 7 56
21 plus
it would be 56
That's why my
it would be 56
You have no case, Mr. Chatterjee. Good.
21.50, 21.50, 43.
just
Indentation error. Also, the present appeal has been preferred, challenging an order dated
But the affidavit of service we kept with the record.
Affidavit of service. You will You are the appellant. Mr.
Yes,
Dawes.
I am for the respondent writ petitioner.
You are the writ petitioner.
Yes.
Yes. That's 17.3.
Yes. Not 17. This is with regard to the counseling of the headmasters. The petitioner was called for counseling. On that, day, certain vacancies in which candidates were recommended prior to that phase of counseling, those had been utilized. Those vacancies could not be offered to the writ petitioner.
Just give us 2 minutes. Let us go through the. Internal. Have you annexed the rules?
Yes.
16 rules.
16 rules, 16.5.
Yes, rule is annexed at page 60,
Yes.
60 of the text.
Who's Korean? If you stay Korean, he stands being dependent. We move to
Dependent working to a available vacancy, not declared
of the persons who were recommended to 9 and 13?
But didn't join.
Yes, the details are annexed. The recommendation.
Is annexed?
Yes.
Please show us that.
And you see annexure P4, page 40. No, page 41.
This was on 25th November 2019. Now, fourth counseling, he appeared on 17th January 2020.
Yes.
Right.
Yes.
But that provision for this commission recommendation, within how many days the board has to issue the letter?
Well, that it is not stated, but my recommendation letter is valid for 90 days.
I see. It was
So,
90
once
days
it's
and
recommended on 25/11/2019, I have to wait for 90 days. Or if the candidate does not go within 90 days, or rather if he reaches within 90 days, we cannot complain that why you did not go within 10 days, 20 days or 30
so
days.
that 90 days window is provided under which rule?
My lord, kindly see rule 17.
64.
64.
Sorry, 16, rule 16.
Is 64, man.
64, na? Valid for 90 days.
Yes.
And it may be extended for 60 days more.
Yes.
On the representation of. So if your argument is that on the date the person refuses recommendation, he should stand de-empaneled. For refusal to join,
yes.
Once he refuses to join, he will be de-empaneled.
Yes, if he refuses to join, but the writ petitioner did not.
Then you argue what is the wrong in this order. Please argue. What are your grounds? (25 November 2019) was the recommendation.
Yes.
The counseling was on 17 January 2020.
Yes.
And that was the fourth round of counseling.
Yes. And one date your lordships kindly take note of. The school intimated by a letter on 28th January 2020. That is page 40.
28th January.
Yes. So the counseling was over. The panel had expired. Your lordships may also record the date of expiry of the panel. Because these are very vital in this case. 15th January 2020.
15 January?
Yes.
2020.
So fourth phase counseling was the last phase. As a matter of fact, the petitioner's recommendation was issued 2 days after expiry, but he was called prior to that. That is why we are not raising any issue with regard to this.
Show us the order which you passed after the matter was relegated to you, which was challenged in the writ petition.
The order
impugned in the writ petition, order of the chairman.
20 March 2020. Page
Reason order,
57.
57.
যদি 90 দিনেও জানিয়ে না জানিয়ে থাকতো 90 দিনের মধ্যেও রিফিউজাল ভ্যালিড থাকবে তার আগে ওটা কাউন্সিলিং এ
রিফিউজ দিয়ে দেয় যে আই শ্যাল নট জয়েন, এরকম যদি স্কুল অথরিটি করে দিয়ে দেয়, তাছাড়া 90 দিন কমিশনারকে কিন্তু অ্যাপয়েন্ট করতেই হবে।
আচ্ছা, those two persons who were recommended in 9 and 13,
Yes,
they did not join.
non-joining post, both the posts are
So
non-joining.
when did they did not refuse to join? Means there is no written communication
No,
by the.
there is a written communication which came after the 17th of January. So it was not available with the
25th
commission.
November, 25th November, 90 days takes you to 25th December, 25th January, 25th February.
Yes.
Now, those they said that they will not join. That you have told
Yes,
us.
kindly see my, everything was annexed by my learned friend to the writ petition.
Before the day on which
Page 40, page 40.
was held.
Court counseling was held on 17 January.
Yes.
আঠাশে ডিস্ট্রিক্ট ইন্সপেক্টর স্কুলকে জানিয়েছে
সেটা তো 28 তারিখ স্কুল জানিয়েছে।
নট জয়েন।
Page 40.
School.
Non-joining district inspector.
That is school informed.
Yes.
No, I'm saying that the candidate who was recommended, did he intimate the school, I don't want to join? Like
Yes, or else this letter would not have been issued by the school. With due respect, I beg to inform you that as per the recommendation letter so-and-so, Mr. Arunava Bose, HM candidate, has not joined
It's not
in this school till date. So he was waiting. So the post of HM is vacant now. This was issued on the 28th of January 2020, after expiry of the patent.
My lord, kindly see for a moment page 64. Page 64, kindly for a moment.
And the next, let me just.
Rules.
Page 42 is with regard to the second candidate. Here again, the teacher in charge is writing to the district inspector.
On 27 January.
On 27 January. Both communications, still it has not yet reached the commission. Call from the commission.
But my lord, kindly see for a moment.
Yes. Page
64.
Yes.
Rule 16, sub rule 3.
Page 60.
64, 64. Rule sub rule 3, my lord.
Yes.
A recommendation letter shall remain valid for a period of 90 days from the date of issue. Then, my lord, provided that the regional commission may, if it thinks,
Extend for 60 days.
60 days. Then, my lord, kindly 4, the concerned school authority shall, on the basis of the recommendation of the commission, issue the letter of appointment to the candidate allowing joining time not less than 30 days. But, my lord, while the school authority was appointing authority, then 60 days, 90 days applicable. But my case, the president of the board is the appointing authority. Kindly see for a moment, rule notification 2018, already I have handed over, my lord, kindly see.
Yes.
Rule 3, my lord.
Appointing authority is
Yes,
the board.
yes. Power and duty of the board. The board, subject to any rule, order, and direction of the governor of the commission, shall have the following power and duties: to appoint headmaster, headmistress, and assistant teacher and non-teaching staff, including librarian, in any institution. Then, my lord, kindly see for a moment page 64. Sorry, my lord, page 41. The recommendation letter issued by the chairman of the West Bengal School Service Commission.
Yes.
Kindly see
90 days.
No, my lord, not 90 days.
The commission shall be
Yes,
informed
yes,
within
yes.
6 weeks.
Yes, from the date of issuance of the recommendation letter. The recommendation letter issued on 25th November 2019. That is 6 weeks valid.
Yes.
The entire process should be completed within December, a first week of January. (2020).
The commission shall be informed within 6 weeks.
Yes.
From the date of issue of this recommendation of
Yes.
the action taken by the board on this recommendation and about joining of the candidate along with his date of joining.
Yes.
Now, in this case, board did not issue the appointment letter.
No, president of the board, kindly see page 43. Bottom portion, issue to the candidate. You are requested to join the school within 15 days from the date of issue of this appointment letter.
Very good. This is on 10th of December.
December 2019. Within 15 days, that means first week of January, the mandatory. Otherwise, non-joining post. But they have my counseling was held on 17th. Prior that vacancy was lying, and they have failed to upload in the portal. Then kindly see for a moment their region order. What they are saying, page my lord 57. On a middle portion, 57, your lordship got. The petitioner applied in first SLST HM 2017 for the post of headmaster, Bengali medium, male category. Petitioner was always listed in serial number such and such and was called for counseling on ATHO. Before the date of counseling, the detailed list of available vacancies are uploaded in the commissioner official website. But those non-joining post was not uploaded.
Your argument was that the time given by
Yes,
the
they have failed to upload in the website. Therefore, I could not get chance to give an option.
But Mr. Shimui, how do you overcome this rule?
Pardon?
Rule says that the recommendation letter will be valid for 90 days.
But subsequent, while the appointing authority was managing committee, then valid 60 days and 19 days. In my case, appointment was issued by the president of board.
Where from do you say that?
Yes.
Had there been any
2018.
had there been any amendment in the School Service Commission rules relating to that 90 days?
Kindly see for a moment rule 18.
Whether it is mandatory.
But appointment says that it is mandatory.
Appointing authority বলেছে 6 সপ্তাহের মধ্যে।
No, whether it is mandatory and where is that provision that if no report is received by the commission after 6 weeks, the vacancy shall be deemed to be.
But appointment, letter of appointment, there is mandatory must be joined before within 15 days. Board also, commissioner also directed the recommendation valid with the inter process should be completed 6 weeks.
60 days part is the mandatory part. 6 weeks is only for a feedback. 6 weeks is not mentioned in the rule.
No, he is totally, he is saying a different thing. He is saying that here appointing authority is the board.
Yes, that is because of the 2018 rule made the board the appointing authority. So the recommendation letters were sent to the board.
Then due to that notification, what amendment was brought into these rules? Must have been happened because the school managing committee does not remain as the appointing
No,
authority.
it does not.
So then there must have been a rule in view of this rule of 2018.
I will have to check. Possibly there was not any, there was no amendment.
So if there is no amendment, then how the provisions of those rules will be mandatorily binding?
Because the selection
That
2016, the candidate
no, if the managing committee, if the appointing authority changes,
yes,
what is the wording of your rule? The wording of your rule 16.5 says that if he refuses,
yes,
you may. It is not that you have to depanel him. you may depanel him. So it is a discretion to be applied on behalf of the commission.
Yes.
This is one aspect.
Fine.
So your argument that once he chose not to join, he is no longer in the panel.
That is the second factor also. The panel expired.
No, that is not the ground in the order impugned before the writ court. Ground by the chairman was that, see, I could not have, I was not known, it was not known to the commission that it was vacant.
Yes.
That is the order.
Yes, yes.
Now then, Mr. Shimui, you should.
এটাও কিন্তু হেডমাস্টার লেখা আছে অ্যাপয়েন্টমেন্ট টু দ্য পোস্ট অফ হেডমাস্টার রুল 16 এ এটা কি সুপারসিশন আগেরটা এডুকেশন অ্যাপয়েন্টমেন্ট কনফার্মেশন ডিসিপ্লিন অফ টিচিং
তো অন্য রুল
Yes, it is a different rule. These rules may be called West Bengal Board of Secondary Education Appointment, Confirmation, Conduct and Discipline of Teacher or Non-Teaching Staff Rules 2018. Whereas this rule may be called West Bengal School Service Commission Selection for Appointment to the post of Headmaster, Headmistress in Secondary.
Yes.
That means these rules relates to selection and this rule relates to disciplinary proceedings such and such.
No, sir. No, my lord, also appointment letter to issue appointment to appoint headmaster and headmistress.
Yeah, maybe.
No, where is that in the rule? In the rule where it is said managing committee will be appointing.
Yes, 64.
64 years. Concerned school authority shall on the basis of recommendation.
Yes.
Now this instead of concerned school authority, now it will be the board.
Yes, my lord.
Now, had there been any such amendment in the rules due to this? Because this is a separate rule. This is a draft notification. We don't know whether this rule has come.
Yes.
It has come. এই রুলটা হচ্ছে সেকশন 45 of West Bengal Board.
Board of Secondary Education Act 45.
But the amendment যেহেতু appointing authority টা change.
Appointing authority board the board subject to order issue direction of following power to the appointment headmaster will be assistant teacher, non-teaching staff, including at
January expired
headmaster.
এখানেও তো তাহলে
On the basis of recommendation.
For the purpose of taking disciplinary action, the board will be treated as the appointing authority.
না এখানেও তো অ্যাপয়েন্টমেন্ট
আমি যখন এই রুলটা করবো এই রুলের for the purpose of taking action appointment and confirmation.
তাহলে তো বোর্ডে চিঠিটাই ইস্যু করতো না অ্যাপয়েন্টিং যেটা 6 উইকস টাইমটা দেখাচ্ছে এই যে পেজ 42 পেজ 43
তাহলে রিকমেন্ডেশন বোর্ডের কাছে পাঠানো হবে স্কুলের কাছে কেন
পাঠানো হয়েছে তো রিকমেন্ডেশন
বোর্ডের কাছে সেটা ঠিক
এই যে বোর্ড পেজ 43 এটা ইস্যু করছে
তাহলে বোর্ডের কাছেই পাঠিয়েছে
এবার যেই বোর্ডের কাছে পাঠালো তোমার এই রুলটাতে তো স্কুল ম্যানেজিং কমিটির অ্যাপয়েন্টমেন্টের উপর স্কুল কমিটি যে ইনফর্ম Because it stands if
Our
court
difficulty,
has given some reasons.
yes,
Single judge has given ABCD for this reason. So we will interfere only when when it is absolutely bad. Otherwise,
it is difficult for the commission because all our selection processes follow the same procedures, and the same situation will arise in hundreds of cases. That the vacancy has not yet come back to the commission, yet I am holding the next phase of council.
that will persuade you to make necessary amendment in the rules,
No, even-
making it incumbent upon you fix a mandatory period. Because your 90 days and de-empanelment is subject to a discretion which you will apply. May, the word is may. So it is not that 90 days gone, you are gone. I will go to the commission again, that do something for me in this sort of service. So first argument subject to what he argues may not be. But the thing is, the rule provides that why your argument that if this happens, then in all selection processes, after attending the counseling and without joining the post, he will again come back and say that give me that.
And here also the petitioner has blocked one school. It is not like that he chose a school. He came for counseling, but he did not join. We could not offer that school because it was on the verge of expiry of the panel. Petitioner has blocked one HF post unnecessarily. His conduct is also to be looked at. He was called for fourth phase counseling.
Yes, he did not accept. He tried his life.
Declaration, but he did not go.
No,
But
Without a teacher till date.
immediately I have informed.
But that will not help because the panel has expired. I cannot utilize.
No, 17. He preferred a writ petition, sir. Issue was relegated for consideration.
Yes.
So his application was not time barred as such. Court exercised decision sending.
But his conduct has now left a school without a HM. That is what I am submitting.
Then we pass our orders. You produce that amendment, if any. Arguments, anything else you want to argue?
My lord, let me come back once tomorrow.
Tomorrow it may not be possible.
Any day convenient to your lordships. I will check the amendment also.
Constitution by the 2018 rules. Any amendment has been brought within the Commission Act.
And if you accept your contention that the time will be 6 weeks, then immediately after the expiry of the 6 weeks, the post shall be deemed to be vacant. Have you got any such rule?
But their region order itself shows the vacancy upload immediately. Region order itself shows that we have uploaded a vacancy post.
Is that did not include those schools?
That was not.
But my lord, prior that it is admitted fact, prior conducting the counseling, the vacancy was lying.
How? He is to wait for some time.
No, my lord, after 15
No, vacancy is lying, but they are saying that we don't know about that vacancy.
There is no
As per
compulsion under
the condition of the appointment, the entire process should be completed within 15 days.
No, that is not the rule. That
Sombhav.
is there. Suppose today what is the wrong done by the commission? Commission says that I could not upload it on 17th of January because I had no information that the person has failed to join. At that time, there was no incumbent upon them also because the period of 150 days was already there.
90 days.
What
90
is
days
the
we are- 90 days.
what is their infraction? What is their here? Court said, last paragraph, the learned single judge said, commission having not declared the vacancy position of 19 and 13 have conducted itself in contravention and derogation to the rules. This finding, subject to what you say, is otherwise,
Apart
Mr.
from
Shimu, then it
the
may
recommendation letter issued by the board, sorry, my lord, school service commission.
show us any provision that there was amendment. Rule has said now that because the appointing authority has changed, now it is a statutory authority. It will be 6 weeks. That is mandatory. Then we will not interfere.
Not in this way. The commission, if do not find any information regarding joining in that post immediately after expiry of 6 weeks, then the commission shall be able to display the same as vacant and shall be able to recommend any candidate for this post. You consider from the aspect of the commission also. Justice is to be given to both sides.
But
What
I
is
could
that?
give the managing committee appointing authority, then I have no case. The board is authority, then I have case.
Show us something. Show us something. We will help you. We will throw away Miss Dr. Pathur. You show us that this 6 weeks time mandatoriness will arise in conjoint reading of the rules. This is the amendment. This you show us. Otherwise, Mr. Shimu, it will open a floodgate. Everybody will appear saying this is not a school near to my residence. I will not appear. I will wait for the next vacancy. Let us wait for 150 days, but within 150 days, the panel also will expire. Okay.
I shall try to.
কি ছিল কবে দিয়ে দাও একটা the day after tomorrow.
Day after tomorrow. Yes.
So we that will leave you.
এর মধ্যে বেঁধে এটা করে তারপর মেন বানাতে
And had the learned advocate appearing for the respective party list the matter for further consideration.
December 1st week করে দাও, entry order text.